Well, a 2-year study has found that the country's law on whether people have the mental capacity to make decisions needs an overhaul. Dunedin barrister Alison Douglass has just published her findings on the protection of personal and property rights, the Triple P law, which is 3 decades old. The law covers adults who have impaired decision-making ability through dementia, learning disabilities, mental illness or brain injury. The research, which is funded by the Law Foundation, says the law is out of date and unnecessarily complex, with no oversight over how it's implemented. Alison Douglass says the rise of dementia and Alzheimer's disease with an ageing population means there are more people with mental impairments in the community and more need to support them. Indeed, many families will find themselves dealing with these decisions, undoubtedly, as time goes by. As part of the study, she's also worked on a toolkit with an ethicist and a doctor on how someone can be assessed on their mental capacity. Alison's in the Dunedin studio. Very good morning.
Good morning, Catherine.
The first thing I think that many people might be think of when they think of this kind of conversation are things like powers of attorney. Is this part of what you've been doing, or is that a separate piece of legislation?
No, that's part of the law, the Triple PR Act, the Protection of Personal and Property Rights Act, which we call the Triple PR Act. That's our adult guardianship law, and it covers both court appointments of welfare guardians and property managers, as well as the law around how we make powers of attorney for when we become mentally incapable.
And that's a very big issue with an ageing population, obviously, and many family members finding at some time they're going to have some tough conversations, and obviously people might well want to plan ahead about these things as well.
Yes, well, it's a law that, it's an oldie and a goodie in the sense that it has sort of good bones. It was an adult guardianship law that came into being in the late 80s. Around the time of deinstitutionalisation of a number of the psychiatric facilities. So people will remember Kimberley, for example, in Levin. And there was a need when people were being placed in the community, particularly people with intellectual disabilities or learning disabilities, to have a process to enable others to be able to make decisions for them. So it was legislation of its time, really. But now there's quite a different sort of social environment. We've got this explosion of elder care and a real need to have a workable sort of legal framework to respond.
So its genesis was actually, as you said, the era of deinstitutionalisation, but it is covering a whole variety of circumstances that people might be in. Can you explain, the various circumstances that it applies to?
Yes, well, I work as a court-appointed lawyer for the family court, and so I get appointed under this legislation to represent a whole range of people. So that can include, often it's older adults who find themselves in hospital for whatever reason, and dementia sort of appears, and there's issues around their living arrangements, and sometimes whether they should be held in secure dementia units, or whether in fact they can return to their own home or need supported living arrangements. But there's also a wide other issues. People with mental illness, for example, may also lack capacity for decision making. And also we have people with learning disabilities, perhaps younger adults who are wanting to leave home and live in supported living arrangements, and decisions being made about them. And also ACC claimants, people with acquired brain injuries, people, for example, might have had a head injury, and again, they need support in decisions that affect them.
Your research concludes there's a big need to modernise the law, and these are a lot of different circumstances it's got to apply to. Can it be a law that applies to all of them? Are there some fundamental commonalities that can be applied?
Yes, is the short answer. So I went to England and looked at their mental capacity law there, and they have one law that covers all of this area, and it's given a real focus to the law, so that whether or not it's medical decision making about whether a person can give informed consent or the right to refuse medical treatment, or whether it's issues about whether or not people's living arrangements or decisions in around their social care. The one law in England applies to everyone, and a particular feature of their law is the code of practice that they've developed, which means that many people, the people that are working with people with disabilities, such as social workers, doctors, nurses, and people in the health system, have guidance and very much focused on getting the right outcomes for people with disabilities.
Your studies concluded that there's two main weaknesses, I think, if we just simplify it. And what would those be in the existing law?
Well, first of all, there is a strong need to update the law. So we need a simple, clearer law where we can understand the key concepts. So the first one is capacity, and the idea that this is the bright legal line where if a person has capacity, then they can make whatever decisions they like, even indeed unwise ones, whereas if they lack capacity, other people will make decisions for them. And that's the second concept. It's the concept of best interests, and that's how decisions are made for other people. And there's now a shift in thinking through the UN Convention on the Rights of Persons with Disabilities about how we can support people and involve them in the decisions about them. So there's now a move to look at best interests as a way of looking at what is the person's will and preferences and put their desires at the centre of the decision making about them.
So it's not entirely the removed from them, even in a situation where someone else may. How can I explain this? They're always going to have some input, regardless of what the capacity or incapacity decision is.
That's right, and that's really how supported decision making can work in the law. So the trick is really how to build that in to make sure that we do have supported decision making for people that are unable to make decisions for themselves.
Instead of just having them done to them, they're clearly involved.
Well, we face a real problem because we don't define what best interests is in law, and that is a problem because there's no transparency as to what that standard is for decision making, and we run the risk of relying on effectively old English case law, where best interest had a very paternalistic flavour, which was about what the doctors think best, rather than a wider approach which now looks at a whole number of people, first of all focusing on what the person's will and preferences are, but also having a sort of a broader approach to
things like what they may have expressed in the past. For example, someone, as you say, someone who may be having some of the impacts of age through dementia, if they've been very clear in indicating in the past their wishes and feelings, that should carry some power. Would that be an example?
Yes. And these decisions aren't always clear-cut, of course. So that's why we need some transparency about how these decisions are made. Because at the moment, there's nothing that gives us guidance in our law or in any code of practice about how these decisions can be made with people rather than about them.
What's in your toolkit then? Just what are you proposing could be practically applied?
Well, the toolkit followed a survey that I did with some doctors and ethicists, so mainly Greg Young, a psychiatrist who I've worked with, and what we became aware of is that there is no sort of national guidance for doctors about how to assess mental capacity. And I should say there are other health practitioners that get involved. I mean, there's no reason why, for example, nurses aren't involved with this as well. But as a starting point, what we did was survey doctors who enthusiastically responded, and it made very clear that many doctors don't have any training on how to assess capacity. So the toolkit is really about providing a consistent national guidance and an approach to assessing capacity. So the law says that there is a presumption of competence, that everyone has capacity to make their own decisions unless proven otherwise. So a capacity assessment is about whether or not a person in fact does have capacity and whether you're going to overturn that presumption. So it provides a sort of a structured basis upon which people can be interviewed. And so it's a combination of both a clinical and a legal toolkit.
It's really interesting stuff. I'm just looking at those Alzheimer's New Zealand figures. The number of people living with dementia, just one example here of what might apply, is set to triple by 2050.
Can I add to that? So in England, the Alzheimer's Society has said that there'll be 1 million people with dementia by 2025. And one of the other interesting things is that international reviews show that there are many people in sort of hospital care, people on medical wards, up to a third of patients are said to actually lack capacity to be able to consent or refuse medical treatment. And on psychiatric wards, it can be up to 45%. So what we need to do is have a legal framework that's able to respond to the sort of avalanche, as it were, of people who have impaired ability to make decisions for themselves.
You've covered this idea of liberty safeguards where people are detained and in care. There's no provision in the current law for reviewing that detention, is that correct?
That's right. So as well as sort of the need to update the law, I've identified two major gaps in our law where New Zealand hasn't responded to the gap, which is where people lack capacity for decision making, but and they're not subject to the Mental Health Act, but there's no sort of check and balance or legal process that governs essentially what is their deprivation of liberty or their detention. So I'm sure people can relate to this. So, for example, when someone is placed in a locked dementia unit, that's the obvious example, where they're under the continuous control and supervision of their carers and aren't free to leave. So this is a real issue that became apparent after a leading case in the UK, and it followed a decision of the European Court of Human Rights, which said that you need to have special rules around governing the loss of liberty, how you identify when someone's been deprived of their liberty and how you monitor it.
What happens now, Alison, with this work that you've done with the support of the Law Foundation? Where, for a start, can people contribute anywhere, and where does it go from here?
Well, my report's now out there, and well, I'm obviously really interested in seeing that there is some law reform here, and I think this is entirely achievable, and it's urgent because New Zealand's been sort of sitting on its hands, really, particularly in relation to the UN Convention on the Rights of Persons with Disabilities. New Zealand ratified that convention in 2008, and there is a real need that, and the government's been told by the UN committee that we do need to review our law here. So I'm hopeful that this will be a
conversation starter at the very least, hopefully an action starter. Thank you.
Yes.
Thanks so much, Dunedin
Barrister
Alison Douglass.